courtroom is ready. Just let me know.
Excuse me. Victoria House Convey. I'm really sorry. Our solicitor had to you only spent 5 minutes talking. We reject you.
All rise. Application and appeal in the matter of Hewes and West Hertfordshire Acute Hospital NHS Trust.
Yes, Ms. Smith.
My lords, my lady.
If junior counsel prefer not to wear masks, they're welcome to do so as far as I'm concerned, but if they wish to wear them, they're welcome to do so as well.
Very grateful, my lord.
I trust none of you in front of them 2 metres away mind. No? Good.
My lords, my lady, I appear together with Martin McLeish
Yes.
on behalf of the appellant, Barry Hewes. My learned friend, Mr. Alexander Hutton, Queen's Counsel, together with Erica Power, appear on behalf of the first and second respondents, the West Hertfordshire Hospitals NHS Trust and the East of England Ambulance Service NHS Trust. My learned friend, Mr. Alexander Antelm, Queen's Counsel, together with Victoria Woodbridge, appear on behalf of the third respondent, General Practitioner, Dr. Pankaj Tanna. As your lordship knows, our respective learned juniors all appeared below.
Indeed.
May I first thank the court for permitting us to appear in person today in an appeal of this density and complexity. It's very much appreciated at this difficult time.
Well, these appeals should be heard in person if possible.
Oh, yes. My lord, the
We've read what we've been asked to read, so we know what this is about.
Very great.
Frankly, we do not want to spend too much time on this application to produce fresh evidence. So what we suggest is, shall we take a DB in the essay and see where we go? It may not feature very much, I suspect, in the course of the hearing. We don't know.
My lord, no. I'm conscious that this case was listed both the application and the appeal. We have had some discussions that indicated the document which the third respondent sought to place before the court can go in the court bundle.
It can.
And I think it has gone in the court bundle. I anticipate.
That's all agreed, is it?
My lord, it's my application.
Yes.
I'm very sorry that your lordship didn't receive a message which we sent on Friday, that obviously subject to your lordship's approval. This was a matter which we realised should not take up the court's time.
Well, it was regrettable.
And we've agreed.
It's regrettable that it generated witness statements of the length they did, really.
Yeah.
Okay, let's crack on. Thank you very much, Sandra.
My lord, the appellant, Barry Hewes, together with his wife, Kerry, is following the broadcast of these proceedings, as are each of our instructing solicitors.
Right.
And just on that point, my lord, we would seek your lordship's permission to keep our mobile telephones on, so that instructions can be received via WhatsApp message if need be. Clearly, our learned juniors have their laptops, but sometimes in terms of timing, it is quicker to get the message in that form.
Okay, and if you need a break at any stage, any of you to discuss with clients, let us know.
Very grateful, my lord.
Good.
And your lordships and your ladyship should have 4 bundles of documents, a blue core bundle,
Yes.
410 pages, although tabs 12 and 13 should now have been removed, those related to the application, so those can be removed if they haven't. A charcoal supplemental bundle, 1 of 350 pages, a light grey supplemental bundle, 2 of 396 pages containing the transcripts, and a green authorities bundle. My learned friend, Mr. Hutton, has a document to place before you with the consent of the parties.
I'm very grateful, my lord. I'm sorry to add to the bundles, but it's just a 2-page document which has been agreed should go in the bundles. Can I hand up copies?
Which bundle does it go in?
It goes in the grey bundle, supplemental bundle 2, and it goes at the end of tab 1, after page 25, and it's numbered 25A and 25B. 3 copies.
Thank you very much. Thank you.
I'm very grateful.
Right.
Lord, in terms of timings, I anticipate, subject to the court, that I shall be on my feet for all of today and possibly slipping a short time into tomorrow morning. The respondents should clearly have a similar amount of time between the two of them to respond, and there should be a short time left for any reply from me on Friday.
Well, try and tailor your submission so that you finish today, would you please?
Of course, my Lord. My Lord, the appellant Barry Hewes appeals with admission of Lord Justice Macomb granted on the 12th of December of 2019 against the order dated the 30th of May of 2019 of Anne Whyte QC, sitting as a Deputy High Court Judge, dismissing his claim against the defendants following a trial of liability only. I shall refer to Anne Whyte QC simply as the judge from here on. The appellant submits that the judge was wrong in numerous aspects of her judgment, ranging from errors of law to errors of interpretation to errors of fact, and that these errors mean that the judgment cannot stand. My Lord, the appellant invites the court to quash the order of the 30th of May 2019 and to order a new trial. My Lord, this clinical negligence case concerns a horrible condition called cauda equina syndrome. If the condition is not addressed at an early stage, it can result in life-changing injuries.
Chester and Ashraf was a cauda equina case, wasn't it? Chester and Ashraf was.
It was a.
I'm afraid it's quite. Makes quite a common appearance in the courts, unfortunately.
Well, it does make quite a common appearance in the courts, my Lord, yes. Chester and Ashraf related to damage caused by or as a result of spinal surgery. So slightly different
All right.
from the scenario. But my Lord, clearly, cauda equina is a very serious condition.
Indeed.
It's not a condition which is widely known of among the general public, unlike, for example, a stroke or a heart attack. However, when cauda equina syndrome begins, it requires diagnosis and treatment just as urgently as those very well-known conditions. My Lord, of course, low back pain affects millions of people every year, and in most cases it improves without surgery. But severe back pain can be a symptom of cauda equina syndrome. Cauda equina syndrome occurs when the nerve roots of the cauda equina are compressed and disrupt motor and sensory function to the lower extremities, the saddle area, and the pelvic organs. It can lead to double incontinence, total loss of sexual function, disabling neuropathic pain, and even permanent paralysis. My Lord, the collection of nerves at the end of the spinal cord is known as the cauda equina.
Now this is an appeal, it's not a rehearing, all right?
My Lord, yes. I'm just trying to give the medical background, my Lord. The spinal cord, my Lord, ends at the upper portion of the lumbar spine, and the individual nerve roots at the end of the spinal cord provide motor and sensory function so the legs and the pelvic organs continue along in the spinal canal. And the cauda equina is the continuation of these nerve roots in the lumbar region. And these nerves send and receive messages to and from the lower limbs and pelvic organs. My Lord, these nerves share the same proximal nerve roots, S2 to 4, which are located in the centre of the spinal canal and are therefore vulnerable to compression from a large central disc prolapse. My Lord, to quote the British Association of Spine Surgeons and the Society of British Neurological Surgeons, CES is a relatively rare but very disabling condition. It causes misery to affected patients that is reflected in the cost of managing the disability and the litigation which results from it. It most commonly results, my Lord, from a massive herniated disc in the lumbar region, and a single excessive strain or injury may cause a herniated disc. However, disc material degenerates naturally as a person ages, and the ligaments that hold it in place begin to weaken. As this degeneration progresses, a relatively minor strain or twisting movement can cause a disc to rupture. And of course, my Lord, there are other possible causes of it, including trauma and surgery. My Lord, patients with low back pain should be aware of a number of red flag signs or symptoms that may indicate cauda equina syndrome. These include severe or progressive motor weakness, sensory loss or pain in one or more commonly both legs. Second, the loss of reflexes in the extremities. Third, difficulty in initiating passing urine or impaired sensation of urinary flow. This may lead to urinary retention with overflow urinary incontinence. Fourth, loss of sensation of rectal fullness. If untreated, this may lead to fecal incontinence. Perianal, perineal, or genital sensory loss, sometimes referred to as saddle anesthesia or paresthesia, and laxity of the anal sphincter. Importantly, my lord, if a single red flag for CES is present, then CES should be suspected until ruled out or confirmed by an MRI scan. To quote the BAS and the SBNS again, a patient presenting with acute back pain and or leg pain with a suggestion of a disturbance of their bladder or bowel function and or saddle sensory disturbance should be suspected of having a cauda equina syndrome. Most of these patients will not have critical compression of the cauda equina. However, in the absence of reliably predictive symptoms and signs, there should be a low threshold for investigation with an emergency scan. And the reference, my lord, is Supplementary Bundle 1, tab 36, page 335. My lord, the diagnosis of cauda equina syndrome is a clinical one confirmed by concordant MR imaging. The appropriate investigation of these patients is by way of an MRI scan, and that MRI scan should be undertaken as an emergency. It is very difficult to justify waiting until the end of an elective MRI list. And again, that's the same reference, Supplemental Bundle 1, tab 36, page 335. If the MRI confirms cauda equina compression, decompressive surgery should be performed at the earliest opportunity. This is a surgical emergency. Nothing is to be gained by delaying surgery, and there's potentially much to be lost. The aim of emergency decompressive surgery for CES is to preserve that function present at the time of surgery, with some scope for improvement post-operatively. In terms of classification of CES, the relatively extensive medical literature on the topic divides preoperative CES patients broadly into two categories: incomplete CESI and complete CESR, where the R has always stood for retention, shorthand for retention of urine with overflow incontinence. In broad terms, if emergency decompressive surgery can be performed on a patient when they are still CESI, the outcome is likely to be favourable in terms of preventing further neurological deficit. As for a patient with CESR preoperatively, although favourable outcomes have been reported in a significant minority of cases, and although they remain a surgical emergency, the post-operative outcome is unlikely to be good in terms of preservation of continence or sexual function.
Yeah.
My lord, your lordship's mentioned Chester and Afshar, which is rather different from the typical cauda equina syndrome case that comes before the courts. But from our researches, we believe this is the first clinical negligence delay in diagnosis/treatment of CES to come before the Court of Appeal. CES claims are particularly difficult for the courts because they often involve, as here, multiple defendants, extensive consideration of what would and should have been done by third parties in the absence of the alleged negligence, including reconstruction of detailed hypothetical timelines and complex medical literature. My lord, we've already identified at paragraph 2 of our skeleton argument that this appeal raises important issues as to, first, the duty of care owed by an out-of-hours GP who conducts a telephone consultation; second, the scope and nature of the duty owed by those providing treatment where time is of the essence and all aspects of the claimant's treatment are time critical; and third, the issues of medical and legal causation in CES. And my lord, these are set out further in the core bundle at tab 15 where that appears. However, my lord, this appeal is also of wider importance in the context of the relatively large number of patients who have poor outcomes with CES and who then bring claims for damages. Back in 2009, 11 years ago, Larvey et al. Wrote about CES in the British Medical Journal, and it's tab 31 of Supplementary Bundle 1, page 304. They noted then that CES is a clinical area that attracts a high risk of litigation. They noted further that persisting CES has a devastating effect on personal and social life, and its mismanagement is one of the commonest causes for litigation in spinal surgery. Most patients are young to middle-aged and in work before they develop CES, so the size of claims is large. They noted that from 1997 to 2006, the NHS Litigation Authority dealt with 107 cases in England in which care in hospital had been compromised. they extrapolated that this suggested that at least 10% of cases involved litigation. My Lord, the position has moved on. From January 2008 to December 2018, NHS Resolution received 827 claims for incidents of cauda equina syndrome relating to hospital care in England. Out of those 827 claims, 340 or 41% were settled with damages, 212 without merit, and as at the 20th of July of this year, 275 remained open. And that's from an NHS resolution document called Did You Know Cauda Equina Syndrome. These figures, my Lord, of course, do not include claims against NHS health boards in Wales or claims where GPs were the only defendants. So the true volume of claims in England and Wales is likely to be much higher, hence the wider public importance of this appeal. My Lord, in March 2012, Barry Hewes was a 43-year-old, tall, slim postman who had been suffering with increasingly troubling low back pain. Your Lordship, I hope, has the agreed chronology at tab 11 of the blue core bundle.
Yep.
Your Lordship will see from page 155 that from May 2011 onwards, Mr. Hewes was reporting a history of low back pain and seeking medical assistance for that. He was referred for physiotherapy in the summer of 2011, discharged in September of 2011. It was getting worse again with sciatica at 3rd of November 2011, low back pain getting unbearable, and he was referred to the orthopaedic team at Hemel Hempstead Hospital, part of the First Respondent NHS Trust. He was seen at Hemel Hempstead in December 2011, and an MRI scan was arranged. That MRI was performed 17th of January of 2012, showing a disc bulge at L45 and a disc protrusion. He was reviewed at Hemel Hempstead Hospital 31st of January 2012, symptoms not getting better, and he was advised to have an epidural injection. Had that on the 22nd of February 2012, and then by the 7th of March, he noticed his back and leg pain had become worse. And so, my Lord, Mr. Hewes was known to Mr. Dyson, consultant orthopaedic surgeon at Hemel Hempstead Hospital, part of the First Respondent Trust. On the Sunday, the 11th of March of 2012, he telephoned the out-of-hours service just after midday and was advised to come in, and he attended what's known as the Urgent Care Centre, UCC is the abbreviation, in Hemel Hempstead, with worsening back pain which was radiating down his leg, and seen by Dr. Sivaso Ruben, and he was advised to attend hospital if he experienced any...
I think the advice was to attend A&E, wasn't it?
My Lord, it was, I think, to attend hospital. It may have been to attend A&E.
I thought the judge found that the advice was used to attend A&E at hospital.
My Lord, I'll check.
This is
The day before. Yeah. Sorry, 2. Thank you. My Lord, it's supplemental bundle 1, charcoal bundle, tab 40. That's the just before that, my Lord. Tab 38. Page 338 is the note of Dr. Sivaso Ruben. And we can see what's set out there. Full bladder and bowel control, no numbness, no weakness, just above the upper ring binder hole. And then about halfway down, the examination details, treatment advised on rest and analgesics to see the GP, if not better, / call back if any concerns. Follow up, patient to contact own GP. So that's the note that we have from that Sunday. My Lord, in terms of the claimant's evidence in relation to that, it's tab 4 of the same bundle, page 6. Paragraph 7, 3 lines down. She also said that if I started to feel numb anywhere, I should get to a hospital as it was a medical emergency.
Right, okay. It's just that I was looking at paragraph 51 of the judge's judgment.
Indeed, my Lord.
Just the last sentence of paragraph 51.
My Lord, yes. And
I also note the GP saw Mr. Hewes' previous done up until March with apparent device into 10-day and if experienced numbness.
Well, we say that's one of the judge's errors.
Right?
My Lord, Mr. Hewes went to bed at about 1 o'clock on the Monday morning of the 12th of March, and he was able to urinate just before going to bed.
Yeah.
He awoke at 5 on that Monday morning with increased pain in his legs and numbness around his groin and saddle area. He and his wife Kerry made various telephone calls to the out-of-hours GP service and dialed 999. And during a call at 0604, Mr. Hewes reported to Dr. Tanner, the third respondent out-of-hours GP, numbness in his bottom leg and testicles. Dr. Tanner queried cauda equina syndrome and advised Mr. Hewes to attend accident emergency at Watford General Hospital, also part of the first respondent, for review. In the meantime, the second respondent ambulance trust called Mr. Hewes back and at 0644 arranged a green 4 ambulance attendance within 1 hour, which arrived at 7:21 and departed his home at 7:38. And at 0819, he arrived at Watford General Hospital's accident emergency by ambulance. He was initially reviewed by Dr. Roffey, A&E FY2 doctor at 0920, and then reviewed, as the judge found, at 10:40, accepted by orthopaedics, at 10:50 to 11:20, the assessment by Dr. Kirkby, orthopaedic FY1, so at the very most junior level of doctor. Importantly, my lord, Mr. Hewes' anal tone was recorded as normal by both of those doctors. And Dr. Kirkby queried cauda equina syndrome. At 11:23, Mr. Hewes had a spinal X-ray, which was, in passing, of no utility in investigating suspected cauda equina syndrome. A bladder scan at 12:03 revealed a residual urine volume of 621 millilitres, indicating that Mr. Hewes was in painless urinary retention.
Yeah.
Mr. Hewes was asked to try to urinate and was unable to urinate despite trying. At 13:32, he underwent an MRI scan, which concluded at 13:50 and which confirmed CES. By 1400, the MRI images would have been available for review on the computer system. At 14:40, a urinary catheter was inserted, which he could not feel. And at about 1500, the orthopaedic registrar, Mr. Mackenzie, recorded that Mr. Hewes had no anal tone and decreasing perianal sensation. A decision was made with the involvement of the on-call orthopaedic consultant, Mr. Langdon, to transfer Mr. Hewes by ambulance to Queen Square, the National Hospital in London, for surgery. He arrived at Queen Square at 8:09 that evening, and discectomy surgery commenced at about 2300, lasting until 1 o'clock the following morning. And on the 14th of March, he was informed he had permanent CES. So, my lord, by Monday the 12th of March, Mr. Hewes was there for a follow-up patient, both to the out-of-hours service, follow-up from the previous day, and also to the first respondent NHS trust, he having been a patient of each with complaints of significant low back pain in the very recent past. From 5:43 on that Monday morning, Mr. Hewes, as so many of us do, placed his trust and his care in the hands of the NHS, through Dr. Tanner, through the ambulance service and through the hospital. Sadly, despite Dr. Tanner's correct initial suspicion of CES, Mr. Hewes was not managed adequately as an emergency throughout, and by the end of that fateful Monday, he suffered injury as a result. Mr. Hewes, my lord, has been left with the typical features of severe CES. He is doubly incontinent, requiring intermittent self-catheterization to manage his bladder and peristine irrigation for his bowels. He has no useful function in either bladder or bowels. He has dense sensory loss in the saddle and perineal area, neuropathic pain in the saddle, genitals and left leg into the left foot. His sleep is disturbed by ongoing dysesthesia, an unpleasant abnormal sense of touch in the left foot, which hasn't responded to anti-neuropathic medication. He has marked sexual dysfunction. He will not make any useful recovery, and these aspects of his condition are permanent.
Well, as the judge recorded, Mr. Hewes is obviously deserving of the greatest sympathy.
Of course, my lord.
And it is enormously to his credit that apparently his approach to litigation has been very dignified, as the judge put it, she having heard him give evidence.
Indeed, my lord.
That's very much to his credit.
Thank you, my lord. My lord, in terms of the position regarding breach of duty at trial, the second respondent had admitted before trial that the claimant's condition was a 30-minute green to emergency, and that error resulted in a delay of 19 minutes. And the claimant didn't pursue the allegation that the ambulance service was also in breach of 0602. The claimant alleged that the third respondent failed in breach to contact the on-call orthopaedic team at Watford General Hospital and ensure that he was seen by the on-call orthopaedic team on arrival, i.e. as an orthopaedic expected patient, thereby effectively bypassing...
Is it your case that in all such situations where cauda equina syndrome is suspected, that there should be a reference to the on-call orthopaedic team, or is it your case that it's so in the particular circumstances of this particular case?
It's subject to local arrangements, my lord. So one can think of particular geographical or resources issues, which might mean that, for example, a local hospital only had an accident in the emergency department, but did not have any...
So it's not your case that in all situations such as this, it will always be wrong to refer to the AE?
No, no. It's subject to local arrangements.
Subject to local arrangements.
Yes.
Thank you.
My lord, in relation to the first respondent, NHS Trust, the allegations were a failure to assess, diagnose and investigate and confirm Mr. Hewes' incomplete CES within a reasonable and specific periods of delay were pleaded in the particulars of claim, and both first and third respondents denied breach of duty. In terms of particulars regarding the first respondent, it was said the on-call orthopaedic consultant, Mr. James Langdon, should have been contacted after junior orthopaedic doctor assessment by Dr. Kirkby. Second, the MRI request form was not marked as urgent. And third, the MRI was not performed as an emergency, and the elective MRI list should have been interrupted. My lord, in terms of causation, the position at trial was this. The claimant claimed that had it not been for the breaches, his incomplete CES would have been assessed and radiologically confirmed earlier, and earlier successful surgery, effectively by around 1500 hours, either at Watford General or Queen Square, would have meant that he would have retained voluntary bladder and bowel control and normal or near normal sexual function. And a hypothetical factual timeline was pleaded in the particulars of claim. The ambulance service denied that the admitted 19-minute delay would have made any difference. The third respondent, GP, denied that delay of 1 or 2 hours, depending on how one constructed it, was causative of any injury. Of course, my lord, given the judge's findings at trial that the start of the orthopaedic assessment by Dr. Kirkby was at 10:50, that period of 2 hours might potentially be extended. But in any event, the third respondent asserted that the claimant had progressed to complete CES by 12:03, the time of the bladder scan. The first respondent denied causation, said that the claimant would not have bypassed A&E in any event, said the claimant's hypothetical factual timeline was unrealistic, and the claimant was put to strict proof that he was not in complete CES upon waking at 5 in the morning. And the first respondent's case, as pleaded, was that Mr. Hewes was at the latest in complete cauda equina syndrome by 14:45. It was unlikely decompression surgery would have been performed by before 1500. My lord, if I might just turn to our skeleton argument,
yep.
Your lordship has core bundle, blue core bundle, tab 7, page 60.
Mr. Booth, before you do that, was there any issue at trial as to the onus of proof as to when CESR started? Is it for you to show that he was still CESI at putative time, or for the respondents to show that he was already CESR at putative time?
My Lord, ordinarily the claimant would have the burden of proof at trial.
That's what I thought.
And subject to any limitations in the claimant's ability to discharge that burden because of evidential.
There may be evidential
or disclosure,
but that's a separate question.
The burden is on the claimant.
So it was for you to show that he was still CESI at whatever time the judge found or would have found that the operation would have taken place.
Indeed, my Lord, and in effect, the claimant's case at trial was 1,500 hours was effectively the cut-off point. And also, although there may have been some improvement with surgery after that time, broadly because of the catheterization at 14:45, that the claimant couldn't advance a case that surgery any later than 1,500 would probably have yielded a good result.
Thank you.
My Lord, the first page in paragraph 1 of the skeleton argument sets out 4 fundamental failings that undermine this judgment. First, that there are a number of factual errors that punctuate the judgment. Those are in Appendix 1. I don't propose to take your Lordship through them in detail as you have Appendix 1. My Lord, it's always difficult, and I accept it's difficult for any appellant coming before this court and saying the judge made significant errors of fact which led to incorrect findings of fact, both in the interpretation. But, my Lord, where a judgment is unsound for these reasons, the only route for an appellant is to this court. And therefore, when one looks at all the authorities which refer to island hopping and the difficulty of challenging findings of fact, one has to recognise that there are some judgments which are so unsound that they cannot stand, and there has to be a realistic route for an appellant. My Lord, the second fundamental failing is that errors made in relation to the facts are compounded by a number of occasions on which the judge fails to deal with the totality of
just so that one is clear on what you're saying, are you saying that the only reasonable conclusion that the judge could have reached on the evidence was to find in favour of the claimant?
My Lord, no, not in relation to factual causation had the judge conducted the exercise properly, but the judge's treatment of the issue of factual causation in particular was...
So that if your arguments are well based, you're not saying that there should be judgment in favour of the claimant. The matter would have to be remitted for a further trial.
That's the case.
I just want to be quite clear.
Absolutely.
You're not saying the conclusion was perverse in itself. I'm not saying that. I just want to be clear.
My Lord, that's absolutely clear. But, my Lord, just to illustrate that point, if I may, in relation to factual causation, and your Lordships and your Ladyship will have seen from the transcript the time that was taken really by all parties in establishing the particular steps and the time it would have taken for particular steps at Watford General Hospital that day. My Lord, in the judgment, paragraph 78.
Again, I just sound quite clear.
Yes.
And when you're saying what you've just said, you're saying that equally with regard to liability as well as to causation?
No, my Lord.
So you're saying the only reasonable conclusion was that liability should have been found? So
yes, my Lord.
That's the only reasonable conclusion open to a trial judge?
Yes, in relation to breach of duty, yes.
Yep.
My Lord, I was just illustrating in relation to the inadequacy of the judge's findings on factual causation. After all the time that was spent at trial on the issue of factual causation, the judge devoted only one paragraph, paragraph 78, to that issue. and said it could be dealt with briefly.
Well, the judge didn't have to deal with causation at all on her findings.
My Lord, that may be, but the judge did indicate at the start that she was going to deal with all.
I may say so, very wise, but strictly shouldn't have to. Yeah.
But my Lord, that paragraph in particular, if I might just emphasise paragraph 78, there is nothing in that paragraph on the evidence given at trial for the first time by Mr. Langdon on the possibility of he himself performing surgery at Watford General Hospital, and that he had a theatre available to him, and that at any time until 1440 that afternoon he could have performed this decompressive surgery. And my Lord, it's the appellant's submission that is wholly inadequate judicial treatment of what was a central issue. My Lord, coming back, if I may, to the fundamental failings. The third fundamental failing is top of page 2 of our skeleton, that the judge made an error in considering a case of suspected cauda equina syndrome is treated as urgent, whereas once an MRI scan had confirmed the diagnosis radiologically, it had to be treated more urgently or as an emergency. And our submission is this finding is wrong, both as a matter of fact and contrary to the evidence in the case. And fourth, my Lord, I'll come back to that point 3 in a moment if I may, that the judge failed to make any reasoned determination on the central issue in the case, which is that in considering suspected CES, time is of the essence, and the standard in relation to both breach of duty and factual causation is that treatment must be provided as soon as practically possible, and it's illogical and unreasonable to fail to do so. My Lord, a central issue before this court on appeal is what the legal test is with respect to the timelines in an urgent/emergency/time is of the essence case. The appellant's case has always been that he needed to be treated urgently, meaning as fast as practically possible in the context of available resources. In other words, it is not to be measured merely against what other hospitals achieve, thereby producing an apparently acceptable range, but against what was achievable in this particular hospital on the day in question. Namely, when time is of the essence, if a step could reasonably have been taken more quickly, it could not be reasonable or logical to take longer. My Lord, one way to think about this may be as follows. If one assumes that there were 5 steps, A to E, and if one assumes the maximum reasonable total time for steps A to E was 5 hours, and if one assumes the maximum reasonable time for each individual step of A to E was 1 hour, if the defendant could in fact carry out step C in 15 minutes, for example, because of available local resources, it would not be reasonable or logical for the defendant then to carry out step C in 1 hour, i.e. slower than actually possible. And it would accordingly not be reasonable or logical for the total time to be taken to be 5 hours. Rather, the maximum reasonable and logical time would be 4 hours and 15 minutes, and anything longer would be unreasonable and illogical in an urgent/emergency case in which time is of the essence. My Lord, this is important when viewing Mr. Thorpe's evidence, and this is the approach that the appellant believes ought to have been taken to the reasonableness and logicality of the timeline. This is not the way that the defendants or the judge approached it. Also, retrospectively recreating the timeline is difficult and dependent upon the factual evidence. And it's always suited the respondents in this case to take a superficial approach and be vague about much of it, a point ignored by the judge. My Lord, put another way, the appellant's case has always been that from his arrival at Watford General Hospital, he was an emergency case in which time was of the essence. In the context of suspected CES, given the potential consequences for the patient, there is no distinction between the words urgent and emergency. And indeed, my Lord, they are used interchangeably and without distinction by the British Association of Spine Surgeons and Society of British Neurological Surgeons. If I might take your lordships to that reference, it's the charcoal bundle, supplemental bundle 1, tab 36, page 335. My Lord, this is a document which post-dates these events, so one has to be cautious with it on that score. You'll see at the top, British Association of Spine Surgeons and Society of British Neurological Surgeons. It's believed that it dates from 2015 or 2016, and this was referenced by Mr. Thorpe. You'll see in the background section reference to, in the third line, appropriate and timely management. Then definitions, 4 lines down, in the absence of reliably predictive symptoms and signs, there should be a low threshold for investigation with an emergency in capitals scan. The reasons for not requesting a scan should be clearly documented. Imaging, in next paragraph, second line, the investigation should be undertaken as an emergency. It is very difficult to justify waiting until the end of an elective MRI list. The Spinal Societies strongly recommend that MRI scanning should be undertaken urgently. So emergency, urgently, used in exactly the same way without distinction. And then surgery, further down the page, penultimate paragraph, second line, decompressive surgery should be undertaken at the earliest opportunity, taking into consideration duration, pre-existing symptoms and potential for increased morbidity. Mm-hmm. So, my Lord, emergency and urgent are in the appellant's submission the same thing. My Lord, when looking at the appellant's approach and suggested test, this does not mean that one looks at the minimum achievable time for each necessary step in the process of assessment, investigation by way of MRI and decompressive surgery. Rather, the point is that CES is a surgical emergency and clinicians have to move as quickly as possible. What times could be achieved are governed by what was reasonable in the circumstances, breaking down the relevant steps and asking what would be a reasonable time for each such step to be completed. My Lord, the claimant recognised at the outset of the trial that in order to establish a correct time frame, all the evidence would have to be heard before that timeline could be crystallised. And it's important to point out that the claimant's submissions were prospective. These were the factors that would have to be considered in determining whether or not MRI or surgery could have been performed more quickly. My Lord, the key part of the submission is not the point that the minimum achievable is not the test, but rather the second limb, what this means in the context of an emergency. My Lord, reading the transcript of the trial makes it clear that considerable time was spent adducing evidence about how quickly certain steps could have been taken, precisely because this was the manner in which the case was being pursued. It's factually incorrect for the first respondent to suggest that the parties relied on any agreement or concession made by counsel for the claimant during the trial. There is a distinction, my Lord, between the minimum achievable and the appellant's approach to the emergency. The appellant would not suggest that steps ought to have been taken which would not have been reasonable. For example, removing a patient from an MRI scanner or bumping an anaesthetised patient from an operating theatre. That would result in the minimum achievable, but those steps would not be reasonable. My Lord, what minimum achievable means, it seems, is as fast as could possibly be done. and that clearly is not the test, because one has to look at the practicability of the steps in question. But
how about as fast as is reasonable in all the circumstances?
As fast as is reasonably practicable would be
In all the
in all the
circumstances.
circumstances, my lord. Yes.
As you rightly say, things may vary from one region to another.
And one hospital to another, my lord.
Exactly
Yes.
so. Yeah.
My lord, therefore, as it can't be the absolute minimum time, the timeline for each step should indeed be guided by what would be regarded as reasonably practicable. But, my lord, the timeline is not to be measured only by what other hospitals may achieve and what may therefore be deemed as bolum reasonable, because there are plenty of hospitals which might be slower than Watford General for all kinds of reasons, but that doesn't make it appropriate or acceptable for Watford General to be that slow in the particular circumstances pertaining on this day. My lord, the timeline for a given step has also to be the subject of logic in the context of both the claimant being a surgical emergency and the existing factual matrix. Importantly, my lord, it would not be logical to move more slowly than the hospital could practically move in an emergency. For example, if it was bolum reasonable for a step to take 30 minutes, because other hospitals might take that long, but Watford General actually could reasonably... My lord, if it was bolum reasonable for a step to take 30 minutes, because other hospitals might take that long, but Watford General actually could reasonably have done it in 15 minutes, it is belitho illogical for Watford General not to have done it in 15 minutes.
Do you dispute the way the judge has summarised the approach as paragraphs 36 and 37 of her judgment, which she seems to have thought was an agreed position? Do you dispute that?
My lord, we do dispute paragraph 36. Not 37, the essential issues.
Because she recalled that as being agreed.
My lord, yes, and that's not the understanding, certainly of those who appeared on behalf of the claimant who were in court. And the formulation in any event in paragraph 36 is, my lord, in my submission, it's slightly bizarre formulation.
Well, I think the judge in any event codifies it by noting what Mr. McLeish had submitted and has set out in the last sentence.
Indeed.
So as it were, options were being kept open.
That may be.
But, the judge seems to have thought that in broad terms, the way she was approaching it had the concurrence of all concerned.
My lord, that does appear to be the approach, what comes through from paragraph 36. But, my lord, it's from my reading of the transcript, it's not apparent that such agreement was reached. I'm conscious, my lord, that...
I must say, what's wrong with paragraph 36 anyway? What's wrong with it?
My lord, because it doesn't introduce the question of practicability and the need for any reasonable or logical explanation for any delay.
Gee. Well, really, we're not construing a trustee like some ancient lawyer from Lincoln's Inn. We're trying to... Well, she got the word reasonable in.
In one point, I hope to have the word reasonable in, my lord, yes.
And so it's fatally flawed because she doesn't get the words reasonably practical in. That undoes everything, does it?
And, well, logical as well, my lord, yes.
Oh, for goodness sake.
Well, my lord, your lordship has...
You're saying that's illogical, what she set out there?
I'm saying it's, first, an unusual formulation, my lord, and it wasn't the case advanced by the claimant at
All right.
trial.
37, do you accept?
The parties agreed those essential issues.
Good. Well, at least we have that.
Yes.
Okay, but you don't agree. You don't agree that paragraph 36 was agreed.
Indeed.
Thank you.
My lord, the problem that the claimant, of course, had in this case before the trial was the factual matrix. because the claimant did not have all the evidence to know how quickly steps could be taken, and therefore whether Watford General did or did not take them as quickly as they practically could and logically should. And it was this difficulty that Mr. Thorpe was trying to get across in his evidence, because he didn't have the full factual matrix on which to comment properly. And the claimant had always been hampered by the lack of factual evidence. Mr. Thorpe's evidence must be taken in this context too. But, my Lord, the appellant stands by the proposition that just because a step might be bolum reasonable does not make it logical, and therefore acceptable in the context of a surgical emergency and the existing factual matrix in this case. This is what is so key to the difference between what the appellant on the one hand and the respondents and the judge on the other said the correct test is. My Lord, just turning for a moment to the issue of disclosure, the appellant had great difficulty throughout the case obtaining proper disclosure from the first respondent, who appeared to be evasive in response to reasonable requests. And the appellant submits that this lack of proper disclosure has been adversely prejudicial against him. The approach of the first respondent required the claimant to resort to two sets of Part 18 requests, a notice to admit facts and a Freedom of Information Act request, the latter regarding how many emergency CES operations took place at Watford General Hospital, with the answer not being none, despite the first respondent's defence in this case. Aspects of the prejudice...
So what was the answer?
The answer to that Freedom of Information Act request was not, as one might have expected from the first defendant's defence, that none were performed, but rather that operations had been performed for two, I think. Two. Yes. My Lord, if we might then turn to the particular grounds, your Lordship has the grounds of appeal, core bundle, tab 1, page 11, and ground 1 relates to the third respondent, Dr. Tanner, and breach of duty. Your Lordship will have seen that...
Could I just pay tribute to those who prepared the bundles for the court? They've been very well prepared, and it's also very helpful to have different colour schemes as well. So thank you very much for whoever,
thank you, my Lord.
Whoever prepared them. Yes.
The position in relation to the third defendant and breach of duty, your Lordship will have seen that it is and always was a relatively short point. Namely, was it mandatory for Dr. Tanner to have made a telephone call to the orthopaedic department at Watford General Hospital at around 6:15 on that Monday morning, saying chap with suspected cauda equina syndrome is coming in to accident and emergency. Please would you see him as an orthopaedic expected patient? That's the short point that's there. And my Lord, in our skeleton, it's paragraph 3, page 61 onwards, where this ground is dealt with. And my Lord, it's our submission that the judge made fundamental errors in relation to the evidence given, in particular in relation to NICE guidelines on sciatica, or rather NICE clinical knowledge summaries for sciatica, which your Lordship has at supplemental bundle, charcoal bundle, tab 33. The grounds here, my Lord, are that there was a misinterpretation of Dr. Tanner's factual evidence and Dr. Swale's expert evidence in relation to the NICE guidance, contributing to an erroneous conclusion and an unfair assessment of the reliability of Dr. Swale's evidence, failing to have any adequate regard to inconsistencies in the evidence of the third defendant's GP expert, Dr. Russell, and failing to assess those when looking at credibility, and finally failing to apply the legal test in Belitho, namely the logic of the position here. My Lord, going back, if I may, paragraph 3 and the nice clinical knowledge summaries. I apologise, my Lord. I'm afraid not only was the transcript in this case one of the poorer transcripts in terms of inaudibility, but the document at tab 33 is one of the least user-friendly documents that we have in our bundle. So apologies for that. And just to orientate your Lordship, there were 2 pages which were well travelled in this document, which were page 7 and page 10, but they don't match up to the pages we've got here. So, my Lord, page 315.
Yep, page 315.
Where it says scenario management, that's page 7, as referred to.
I see, yes. Yep.
How should I manage a person with
Yeah.
sciatica? And just below that, if there are red flag symptoms and signs that may suggest a serious underlying cause, admit or refer urgently for specialist assessment using clinical judgment. Now, my Lord, GPs don't admit, and so this is a document directed at general practitioners, and so the claimant's case was that urgent referral for specialist assessment was required here. So that's on the basic management point. And then, my Lord, turning to page 318, just below the top paragraph, your Lordship should see the words follow-up. That was page 10, my Lord.
Page 10, yes.
And so, of course, my Lord, as a matter of fact, Mr. Hewes was a follow-up patient. At follow-up, if symptoms persist or are worsening, and we'll see the first white bullet, if there are red flag symptoms and signs that may suggest a serious underlying cause, admit or refer urgently for specialist assessment using clinical judgment. And then if one drops down 4 more black bullets, to consider arranging specialist referral if there is progressive, persistent or severe neurological deficit, admit or refer urgently to neurosurgery or orthopaedics for specialist assessment, depending on clinical judgment and local referral pathways. And so, my Lord, that was the document. Paragraph 24 of the judgment, my Lord, the judge refers to this document. And refers to both pages 7 and page 10.
Yeah.
And, my Lord, if we just look at that and go back to the foot of 318, you will see the bottom paragraph on 318, urgent neurosurgery or orthopaedic referral. The recommendation on urgent neurosurgery or orthopaedic referral is based on expert opinion and US guidelines. Then we have the references which state that progressive neurological deficit may need MRI to help decide if the person is a potential candidate for surgery. That part not quoted by the judge in paragraph 24. But, my Lord, the judge concludes later on at paragraph 46 that Dr. Swale, in his evidence, was referring to page 7 and not page 10 of the NICE document. And it said as well, nor in fact was this put to Dr. Tanner in cross-examination. Now, my Lord, page 10 was put to Dr. Tanner in cross-examination, so that's another error by the judge. And Dr. Swale quoted page 10 of the NICE document in his report. And so,
Was the point put to Dr. Tanner in cross-examination?
Strictly speaking, the follow-up point, my lord, wasn't, I don't think, but page 10 he was certainly asked about.
Again, could I just be clear on this? Is it your case that all GPs, out-of-hours GPs such as Dr. Tanner, presented with this set of facts, should have referred and should only have referred directly to an orthopaedic unit rather than A&E? Or are you invoking Dr. Tanner's, as it happens, particular knowledge? He'd worked at WGH himself in the past. You're not making that?
No.
So, for example, as sometimes happens, a locum GP from an entirely different area had been on duty that night, and that happens.
Does, my lord.
Still, that doctor, knowing nothing about Watford General Hospital or anything, still should have referred to a local orthopaedic unit. Is that your case?
It is, my lord, and it's an important point.
All GPs in this situation should bypass A&E and should refer directly to the specialist unit.
Yes, my lord.
That's very clear.
It is. And my lord, just the important one, of course, might argue that the locum GP who's doing an out-of-hours shift in an unfamiliar geographical area should have familiarised themselves with the local resources in terms
Sometimes they're called in at 24 hours notice.
Of course, my lord, of course. But still, one should not apply a different standard to out-of-hours GPs.
That's totally clear and logical, your position. So you're not saying it's specific to the knowledge, the local knowledge of Dr. Tanner in this particular case?
No.
Yes, thank you.
My lord, we referred a moment ago to cross-examination of Dr. Tanner about page 10 of the NICE summaries, and if we might turn to the light grey supplemental bundle 2, tab 9 of that bundle, we're in the transcript. The numbers used here are the underlined numbers in the middle.
Now, I've familiarised myself with the papers. I have not familiarised myself with the transcripts of evidence.
Of course, my lord.
So I don't know. I speak for either of my colleagues, but I'm not speaking for myself. So which tab?
We're tab 9, my lord.
Tab 9.
And using the underlined numbers in the bottom middle of the page is page 130.
The big bold black one.
Indeed.
Yes, the middle. Yeah.
And this is Mr. McLeish's cross-examination of Dr. Tanner. And you'll see just below A, if you turn to page 10,
yes.
top of the page.
Yeah.
And there's then some inaudible references. And then the question is asked just below C, in cases where you have progressive neurological deficit that mean MRI or potential candidate for surgery, the appropriate specialism is a neurosurgery orthopaedic referral, isn't it? And then Dr. Tanner says, can you just give me one moment, please? It does distinguish, doesn't it, between the two paragraphs at the bottom of page 10. The second bottom paragraph talks about admission or referral if there are red flag symptoms and signs. I would suggest the situation Mr. Hewes was in and the assessment that I undertook led me to follow the recommendation within that paragraph. The subsequent paragraph, which you're now referring to, talks about urgent neurosurgery or orthopaedic, and it talks about further sort of symptoms, the question of neurological deficit may need MRI. I've read that previously again now, but I still feel the case we have with Mr. Hewes fell within the upper of the lower two paragraphs. And the upper of the lower two paragraphs, I think, my lord, is the paragraph I took your lord to a moment ago on page 318. Supplemental bundle 1. And that's the admission or referral if there are red flag symptoms and signs, and so not the paragraph headed urgent neurosurgery or orthopaedic referral.
And then there was some re-examination on that point as well.
So what do you say the difference between the upper paragraph and the lower paragraph is? What distinguishes the two cases?
My Lord, I'm not sure that the upper paragraph says a great deal. It simply refers to a recommendation on admission or referral and what that is based on, and sets out the evidence in support. Clearly, Dr. Tanner was saying that he felt that sending Mr. Hewes to A&E was reasonable in the circumstances.
Dr. Tanner clearly distinguished between red flag symptoms and signs which lead to admission or referral, which was the paragraph which he thought that Mr. Hewes fell into. In the lower paragraph, urgent neurosurgery or orthopaedic referral, if there's progressive, persistent or severe neurological deficit.
Yes.
Was he wrong to read these guidelines as distinguishing between those two different situations?
My Lord, if one goes back for a moment, my Lord, to page 315, which appears to be the management section. I took your Lordships to first of all. It's the middle of 315. If there are red flag symptoms and signs that may suggest underlying cause, admit or refer urgently for specialist assessment using clinical judgment. That yes. appears to be what he was referring to there. But referring urgently for specialist assessment is still referring urgently to orthopaedic specialist, surgeon.
Is specialist assessment not viable at A&E level?
My Lord, in answer, no, it's not.
But this is what I don't quite understand, how you can, I mean, it's not a legal text, but how you understand this should be interpreted by busy GPs doing the out-of-hours service. It seems to me from the answers that Dr. Tanner gave, that the way he understood it was that the guidance distinguishes between two different situations. So if you look just at page 318 at the top, and starts off as you showed us with the first white bullet. If there are red flag symptoms and signs, admit or refer urgently for specialist assessment. And that's picked up at the bottom of the page under the heading admission or referral if there are red flag symptoms and signs. Then going back up to the fourth black bullet, if there's progressive, persistent or severe neurological deficit, admit or refer urgently to neurosurgery or orthopaedics, and that's picked up at the lower of the two paragraphs. So that's how he read it, according to his evidence.
Yes.
I do say he was wrong to read it in that way.
No, my Lord, but what we do say is that referring urgently for specialist assessment, as referred to in the upper paragraph, means what it says, and that accident and emergency does not provide specialist assessment.
But then I don't see what the difference is between the two paragraphs, because if specialist means neurosurgeons or orthopaedic, why does this document distinguish between the two situations?
My Lord, progressive, persistent or severe neurological deficit is clearly a pretty serious scenario. One can see that. But equally, a red flag for cauda equina syndrome is also a pretty serious scenario, just because it's called a red flag rather than progressive neurological deficit is in many ways neither here nor there, because actually it is progressive neurological deficit. This is new neurological deficit since the previous day in the context of a man who had an MRI scan, epidural injection, clearly had disc issues. And so it's very much our case that the sole course and the sole reasonable and logical course was referral to what would in effect have been an orthopaedic specialist.
I haven't quite understood whether that's because you say that if there are red flags and symptoms, refer for specialist assessment means orthopaedics, or whether you say this was actually a case of severe neurological or persistent or progressive neurological deficit, so you should should have fallen within the lower of the two paragraphs. And I'm not quite sure which the case is.
My lord, our case is that Mr. Hewes fell within both here. He had red flag in terms of the new numbness. He also had progressive neurological deficit, given attendance the previous day and given his history recently of MRI and epidural injection. And so this was progressive neurological deficit as well.
So all GPs, all out-of-hours GPs, obtaining information over telephone, which is potentially indicative of cauda equina syndrome, all GPs acting reasonably should refer straight away to the local orthopaedic specialist unit.
Subject to local arrangements, my lord, as indicated. So, for example, if there were a geographically remote location where, for example, the local hospital has only an accident emergency department and has maybe an orthopaedic surgeon coming once or twice a week to it, then in those circumstances it might be reasonable and logical to refer the patient to that accident emergency department. But
why would that be reasonable and logical on your argument?
Well,
what's the point? You're saying what's the point? They should go to a specialist straight away.
Well, they should.
So someone should be ringing for a helicopter or something, taken to Manchester or whatever. That's what you're saying.
But my lord, putting helicopters aside.
No, but I'm just you're using the word logical a lot, so let's use it back at you, shall we?
Of course, my lord, of course. My lord, subject to local arrangements, it would usually be logical to refer a patient such as Mr. Hewes directly to an orthopaedic specialist if cauda equina syndrome, as here, is suspected.
And that is required practice for an out-of-hours GP?
My lord, yes. My lord, if I might turn to paragraph 4 of our skeleton and inconsistencies in Dr. Russell's evidence, it's our submission that the judge failed properly to take into account material inconsistencies in Dr. Russell's evidence. In his report, Dr. Russell had included a range of reasonable options, including an urgent face-to-face GP consultation, and then arranging for Mr. Hewes to be assessed urgently in secondary care. He clarified in oral evidence that he didn't consider that GP consultation to be the best option. He'd only consider it reasonable if the patient could be seen within minutes. But the GP expert's joint statement includes an agreement that cauda equina syndrome can be suspected by a GP over the telephone by the history alone, and examination is not necessary. And therefore, my lord, an unnecessary consultation is unreasonable in the context of a condition in which time is of the essence. And there's no sound evidential or logical basis for Dr. Russell's qualification in oral evidence that it's reasonable if a patient can be seen.
And this was a point taken in the court below?
My lord, yes.
And so you're re-arguing the case again on appeal?
Trying not to, my lord, no.
You are?
But I'm not, my lord, because the position is that here it's the judge's failure to take into account inconsistencies in Dr. Russell's evidence.
This point doesn't go anywhere, does it? I mean, there wasn't a case that there was a delay injected because Mr. Hewes was seen as a face-to-face consultation. It didn't actually happen.
It didn't.
So this is just an attack on Dr. Russell as a witness, is it?
And credibility as an expert, my lord, yes.
Thank you.
Elisabeth?
Sorry, my lady.
Ask a question.
No, I was going to ask the same question.
It goes to his general credibility.
Indeed, my lord.
We're attacking the credibility of Dr. Russell, eh?
My lord, yes.
Right.
And my lord, if I might turn to page 4, little Roman 3.
Here's a witness not to be believed.
My lord, not a witness not to be believed, but in terms of the weight that can be placed on his expertise.
You mean so reliability?
Reliability.
Ah, right.
Rather,
Well,
indeed.
Right, that's slightly better. Yes.
My lord, it's little Roman 3 at the top of page 4 of our skeleton. The unreliability of Dr. Russell's evidence in its approach to delay. was Dr. Russell who said that it would be an urgent referral but becomes an emergency when the actual diagnosis is confirmed. So perhaps that rather set the hair running in relation to the judge's approach to matters. But the apparent distinction between the period pre and post diagnosis on MRI was not pleaded and was contrary to the agreement in the joint statement. And in any event, it's neither reasonable nor logical. My Lord, we refer to a first instance judgment next in the Green bundle. Mr. Justice Green, as he then was in C and North Cumbria in 2014. My Lord, ordinarily before this court, one wouldn't refer to such a decision, but in our submission, this decision contains really important dicta which should be considered and applied by this court. And if I might turn to that judgment, my Lord.
Yeah.
It's the Green Authorities Bundle, tab 1. This was a clinical negligence birth injury claim, and in paragraph 1 on page 2, the judge summarises the narrow question: was it negligent for a midwife to administer a second dose of a drug that induces labour? And after setting out the background facts, from page 6, paragraph 20 sets out the law, noting that there's no material difference between the parties to the relevant test to be applied, and sets out the Bolam test, and then paragraph 21, in the present case, and reformulating the Bolam test, the question is whether no reasonably competent midwife would have acted and exercised her judgment in the way in which midwife Bragg, who administered the second dose, did. Then referring to the approach to expert opinion and Lord Scarman in Maynard, and then at paragraph 23, the test was subjected to analysis in Belitho, where two competing bodies of expert opinion, very well-known passages set out from Lord Brown Wilkinson on page 7, my Lord. And then at page 8, paragraph 25, Mr. Justice Green said this: in the present case, I've received evidence from 4 experts, 2 on each side. It seems to me that in the light of the case law, following principles and considerations apply to the assessment of such expert evidence in a case such as the present. Appropriate expert opinion considers that an act or omission alleged to be negligent is reasonable. A court will attach substantial weight to that opinion. This is so even if there is another body of appropriate opinion which condemns the same act or omission as negligent. The court, in making this assessment, must not, however, delegate the task of deciding the issue to the expert. The issue that the court, taking account of that expert evidence, must decide for itself. In making an assessment of whether to accept an expert's opinion, the court should take account of a variety of factors, including but not limited to whether the evidence is tendered in good faith, whether the expert is responsible, competent and or respectable, and whether the opinion is reasonable and logical. And then those are broken down. Good faith is dealt with at Little Roman 5. Responsible, competent, respectable in Little Roman 6. In Belitho, Lord Brown Wilkinson cited each of these 3 adjectives as relevant to the exercise of assessment of an expert opinion. The judge appeared to treat these as relevant to whether the opinion was logical. It seems to me that whilst they may be relevant to whether an opinion is logical, they may not be determinative of that issue. A highly responsible and competent expert of the highest degree of respectability may nonetheless proffer a conclusion that a court does not accept ultimately as logical. Nonetheless, these are material considerations. In the course of my discussions with counsel, both of whom are hugely experienced in matters of clinical negligence, I queried the sorts of matters that might fall within these headings. The following illustration...
Shall we just read these to ourselves?
Of course, my lord.
To save time. Do you want us to read 7 as well? I imagine you do.
Please, my lord,
Yeah,
yes.
we'll do that. Yeah. concentrate upon the pith and substance of the expert opinion.
Indeed, my lord. See beyond stylistic blemishes. But my lord, in particular, the start of Little Roman 7, the logic reasonableness section.
Yep.
By far and away the most important consideration is the logic of the expert opinion tendered. A judge should not simply accept an expert opinion, to be tested both against the other evidence tendered during the course of a trial and against its internal consistency. For example...
Well, that's in line with Belitho, of course.
Indeed, my lord.
Yes, yes, well, I think we've read those paragraphs. Yes.
I'm grateful, my lord. Well, it's our submission that in the case of Dr. Russell, the judge has not properly evaluated his evidence against the whole of the evidence to assess its logic. My lord.
In a word, where as a matter of logic did Dr. Russell go wrong?
He went wrong by suggesting the face-to-face consultation with a GP, if one could have been available within minutes, and in effect going back on what had been agreed in the joint statement as the reasonable options.
But you've already accepted that that's a side issue.
My lady, yes.
So how logically does that undermine his evidence on the important point?
Because, my lady, the introduction of a advice to go to accident and emergency introduces an unnecessary step in this process and thereby introduces unnecessary delay to the process.
Well, that's a different point.
Well, it's not a point that Dr. Russell appeared to...
But does that go to the quotes, close quotes of his opinion?
My lord, yes.
Which I think is what my lady is putting to you.
In my submission, it does. It does. Because in terms of the overall reliability of an expert's opinion, one has to look at the substance of what they are saying. And Dr. Russell continued to maintain that the face-to-face consultation was a reasonable option when it plainly was not.
But even if that was unreasonable, I still don't understand, if this is a question of logic, how it undermines the logic of his position on the main issue.
Well,
because logic's got nothing to do with credibility. Something's logical or it isn't.
But in terms of the evaluative task which the judge has to carry out, my lady, before preferring one expert's opinion over another, the judge should assess the internal logic of that expert's opinion in toto, so not simply on the issue of whether it's referral or advice to go to A&E.
But if there are separate issues, an expert may be illogical on one issue, but perfectly logical on another.
But their illogicality on one issue may fatally taint their reliability of their opinion on the other issue.
But not if it's an issue of logic.
Not an issue of logic. I can get in trouble debating logic in the Court of Appeal, you know, Mr.
My lord, I'm well aware that one can. However, what's made clear by Mr. Justice Green in C in North Cumbria is the judge has to bring their own evaluation to the process.
That is absolutely right.
I think your point is really this, that the fact that Dr. Russell was prepared to conduct a face consultation, which in your submission must have been wrong, indicates that he wasn't taking a sufficiently urgent view to the CES that was suspected, and that infects his actual opinion on what actually happened, which was the referral to A&E. That's really...
It is, my lord, yes.
What you're saying.
It is.
But isn't that classically a matter for the trial judge to assess, whether she finds a particular expert's opinion reliable or not? I mean, it's quite difficult for us to put ourselves in her position.
I accept that, my lord, and I accept that weighing up competing expert opinions is the bread and butter of the trial judge. And I accept that in this appeal and on this point, that it is difficult, not only for the three of us on this front row, but also for the three of you in looking at this, to actually try to reconstruct the trial scenario. And my learned friends make much of that in their scope.
It's not just difficult, it's physically impossible. One would have to read every word of every expert report and every word of every transcript to even begin to put yourself in the same position as the trial judge. And even then, you wouldn't have the advantages, which are very well trailed in the authorities, of seeing the witnesses in person.
Indeed not.
So what can we do with this submission?
Well, my lord, perhaps take a step back and in terms of the judge's evaluation here, just look carefully at how the judge has weighed the evidence of the respective general practice experts. And it's the important point here is that the judge has simply not taken sufficient account of the point about the face-to-face consultation in conducting that evaluation. And it's one of the
well, it may not be expressly mentioned in the judgment, but we have... It is. Well, it is. But even if it were not, the Supreme Court authority, I'm sure you're aware, that judges are assumed to take into account all the evidence before them unless it can be demonstrated otherwise. And it can't be the case that every judge writing every judgment and assessing every witness has to rehearse every single point that has been urged in submissions, because it would make judgments, which are already very long, completely impossible to complete or read.
My Lord, I accept that. If it might be helpful to be context specific and turn to paragraph 47.1 of the judgment,
yes.
My Lord.
Well, I'm a bit amused by this because you can't say the judge didn't deal with it. 'Cause in paragraph 49, she met it straight on. You see, this is why I'm just getting a little anxious that this hearing is starting to be treated as a rehearing. You can't do that in the Court of Appeal.
No.
And the judge, Mr. McLeish made his criticism fair and square. The judge took it on board and dealt with it.
Indeed.
As my lord has said, as you know perfectly, I didn't need an extra. The feel of a trial can never be got across on transcripts alone.
No, my Lord. I accept that.
All right. Anyway, you want to take 47?
47.1.
Yes.
My Lord, we'll see there an urgent face-to-face GP consultation, and then, if appropriate, an urgent referral to A&E or appropriate secondary care specialist. By suggesting this, Dr. Russell agreed that such a consultation was not necessary, and then his explanation for it. But there is no grappling then with that, the illogicality of that conclusion within the judge's reasoning thereafter. But, my Lord, I won't press the point further, given your Lordship's observation a moment ago.
The judge's paragraph 51. If Dr. Swale is correct, there never would be a logical basis for sending such patients to A&E. That's your position.
Indeed.
And then she says the guidance doesn't support it. I'm not prepared to dismiss Dr. Russell's evidence because he included in his range of options one which he shouldn't have done.
Oh, yes.
And you're saying that's a perverse conclusion?
Oh, yes. It's not a safe conclusion.
And the only proper conclusion is, well, Dr. Swale is right. There never would be a logical basis for sending patients to A&E.
Oh, yes.
Subject to the resources.
Yes.
Your point. Quite an extreme position. Supposing you've got a patient, and here, I mean, you can reasonably pray an aid that Mr. Hewes had a background of spinal problems.
Yes.
And if need be, you can also pray an aid that Dr. Tonner had some understanding and knowledge of WGH. But supposing completely for the first time, out of hours, someone rings up, shall we say, a locum GP, saying, I've got this pain in my back and I'm losing function in my legs. No reasonable GP could, as well, say, well, let's have an assessment by a doctor, a kind of triage, if you like, at A&E first. It's urgent, go to A&E. Sure, is that unreasonable for a doctor not speaking over the telephone who has no previous history of the patient? So, well, I think you better go and see A&E first. Is that just strikes one thing slightly odd?
My lord, it's a slightly different position here, as we know, but your lordship is premising your question on the basis of a fresh call to an out-of-hours service with no history.
Well, as I understand it, you're saying in all these cases, I'm using your own argument,
Indeed.
You're saying in all these cases, all GPs acting reasonably must only refer direct to the orthopaedic unit.
Yes.
So I'm giving you an illustration, which could easily happen in real life.
Indeed.
And you're saying it is simply unreasonable for such a GP, locum GP, to refer to A&E first.
My lord, yes.
Quite an extreme proposition, frankly.
Well, my lord, in terms of the red flags for CES,
Yes.
it's
Yes.
such a debilitating condition that that's the
No,
context.
that's
that's
the
the
way it is.
context.
That's
in
the way it
which
should be.
This is yes.
You don't take risks, you would say. You do not take the risk of delay.
No.
All right.
My lord, I'm in
Why
terms
was
of.
it necessary to sue Dr. Tunner?
I'm sorry, my lord.
Why was it necessary to sue him?
To
Sue him? To take proceedings against him, given your other claims?
because, my lord.
Because he contributes to the overall delay package.
Indeed. As did the ambulance service. My lord, you have our submissions at paragraph 5 on the emergent urgent point. I've perhaps rather
Now we're
make
approaching 1:45 and we're on paragraph 5 of the skeleton, but no doubt we can pick up speed
Indeed.
as we go on. I do understand you have to lay the ground first. I do understand that. Right?
The emergent urgent points, I think, I've probably made already, my lord, in my opening remarks. That in terms of emergency referral to a secondary care specialist, clearly an issue arose at trial as to whether accident and emergency was a specialism. And it's our submission that, simply put, it's not a specialism for these purposes. In terms of the judge's approach to the balancing exercise, my lord, paragraph 6, there are a number of matters set out by way of criticism of the judge's interpretation here, and the way in which the judge erred. My lord, in many ways they are best set out in writing here. The point, perhaps at little Roman 3 on page 5, that the judge's interpretation of the SBNS 2009 standards of care is based on a misreading of the relevant guidance. The local circumstances point, different areas will have different resources and policies which will determine the appropriate treatment pathway, and the availability of an MRI scan will depend on local facilities, and requests for such a scan may require input from orthopaedics, spinal surgeons or neurosurgeons. Clearly, my lord, the judge accepted the position that A&E was a specialist assessment at Little Roman 4, but the point remains that neither Dr. Roffey nor Dr. Kirkby, both of whom were very junior doctors at the time, had passed any specialist A&E exams, and in his evidence, Mr. Thorpe highlighted the risk of patients with a serious pathology being seen by junior doctors and simply being sent home.
Kirkby was orthopaedic. Was the orthopaedic?
I beg your pardon. Yes, I'm reminded Dr. Kirkby was a very junior orthopaedic doctor at the time. I think she was 24 years of age at the time. Was not an A&E doctor. Dr. Roffey was. He was very slightly more senior. I think 1 year more senior. My Lord, Little Roman 5, we say that the NICE clinical knowledge summaries were not drafted on the basis that A&E was specialist. The key point about cauda equina syndrome is the need to obtain an MRI scan. And the judge doesn't refer to this at paragraph 24 of her judgment. Of course, local practices vary. Mr. Thorpe's view, it's rare for MRIs to be ordered directly by A&E without input from orthopaedic or neurosurgeons first. In this case, the MRI scan was obtained following assessment by an A&E clinician, Dr. Roffey, and recommendation by orthopaedics, Dr. Kirkby.
Just remind me, when was the orthopaedic unit at Watford General Hospital open? When did it have people available? What time?
As far as I'm aware, my lord, the evidence is that there was an orthopaedic doctor on call
24
throughout the night. Yes.
There was.
Yes.
That was open. That was 24-hour cover.
Yes,
So that resources issue is not in play here.
The evidence which emerged at trial, I think from Mr. Langdon, was that if there had been a call from Dr. Tanner at about 6:15 that morning, there would have been a doctor which, in old money, he describes as a senior house officer, perhaps with around 5 years' experience, who would be holding the fort in terms of orthopaedic cases.
And that would have been said at midnight as well. That was 24-hour cover.
As far as I'm aware, my lord.
So that issue isn't an issue here.
No.
Good. Thank you.
Did Mr. Langdon not also say that if there'd been a call early in the morning, the patient would have been told to go to A&E?
He did say that.
First place?
Absolutely,
He did.
Absolutely,
He did say that.
He did. And the judge plainly relied on that in coming to the short form conclusion as to what would happen in factual causation terms. My lord, there is no issue that MRIs may be performed in A&E, nor is there any issue that patients will attend A&E either with or without a GP referral. But that is not an answer to Swale's argument. There is no logical basis for sending the claimant to A&E with his history of known disc herniation and when CES is suspected because of a red flag. Time is of the essence, and the A&E assessment will simply duplicate the time that Dr. Tanner has already spent making his assessment. My lord, I'm at Little Roman 7 on page 6.
Yep.
The judge at paragraph 25 of the judgment references the Larvey 2009 BMJ paper, but we say fails to quote the full reference, which Dr. Swale refers to in his report. Well, that paper, it may be helpful just to go to for a moment, is supplementary bundle, the charcoal bundle, tab 31, page 304 is the start of the paper. This is a paper from the British Medical Journal in 2009, so the British Medical Journal, BMJ, journal read by a number of doctors, including GPs. Headed cauda equina syndrome. We can see that the fourth co-author is Jeremy Fairbank, so the first defence orthopaedic expert. And on page 305, my lord, how should suspected cauda equina syndrome be investigated? It's the foot of the left-hand column. Recently published guidelines for the management of patients with back pain and neurological signs recommend urgent surgical referral for suspected cauda equina syndrome. And so just going back to Mr. Justice Green's point about weighing the logic of any argument as against any guidelines that are available or published papers, then in our submission, this is clearly recommending urgent surgical referral for suspected cauda equina syndrome. My Lord, at paragraph 53 of the judgment, the judge refers to the claimant being advised to attend A&E for an urgent scan and that this was not a technical referral. The precise statement is second line of paragraph 53. It is correct that the claimant was advised that he would have to go to A&E for an urgent scan rather than there being a technical referral. Now, it's unclear what the judge meant by a technical referral. The simple fact is that the claimant wasn't referred to A&E, and in arriving at A&E unheralded, he had the same status as the patient arriving off the street, and that necessitated an assessment from scratch and an inevitable delay before he was seen by a specialist. The significance of Dr. Tanner contacting the hospital to ensure assessment by the orthopaedic team was to transfer important information about the suspected CES to allow a timely specialist assessment. My Lord, lastly on this ground, the failure to apply Belitho, spotting the error in paragraph 8 of the skeleton. Despite gentrification, Hackney has not yet progressed to city status, my Lord. It's City and Hackney Health Authority and not City of Hackney Health Authority. Belitho, we've got in the authorities bundle. We've looked at the essence of it already, but just to be proper about matters, tab 3, the facts of Belitho, it's page 38, tab 3 of the authorities bundle, were that a 2-year-old child was admitted to hospital suffering from respiratory difficulties. At 12:40 p.m. on the following day, his breathing suddenly deteriorated, and a nurse summoned the doctor in charge of the child's care by telephone. The doctor did not attend, and in the event, the child recovered. At 2 p.m, he suffered a second episode of acute respiratory difficulty, which the nurse again reported to the doctor by telephone, but the child apparently recovered without the doctor having attended. At 2:30, the child collapsed, owing to failure of respiratory system, as a result of which he suffered a cardiac arrest and sadly sustained severe brain damage. And the relevant passage, of course, well known to your lordships and your ladyship, in terms of the question of the burden test and causation, we have at 45 and 46. But the relevant passage here is the passage starting at 47, just below E. And of course, there we have the responsible, reasonable, respectable adjectives referred to at the foot of the page. And then the satisfaction, there has to be a logical basis. And then over the page, my Lord, 49, A to E. Of course, just around C, if in a rare case it could be demonstrated that the professional opinion is not capable of withstanding logical analysis, the judge is entitled to hold that the body of opinion is not reasonable or responsible. My Lord, here, simply put, the judge in our submission failed to apply Belitho to the issue of whether or not Dr. Tanner was in breach of duty. In particular, as time is of the essence, any delay has to withstand logical scrutiny, and Dr. Russell's evidence included reasons for delay that are clearly unreasonable. Dr. Russell even suggested a reason for not referring the claimant was that there might be 10 or 20 patients waiting for the out-of-hours doctor to answer their calls. Simply put, there should not be a lower standard applied to an out-of-hours doctor than there should to a GP in ordinary practice. The possibility canvassed by Dr. Russell that MRI might not establish CES, again, is really neither here nor there. And the approach of Dr. Swale was, in our submission, entirely logical and internally consistent. Orthopaedic was going to be necessary here from the moment Dr. Tanner suspected CES, and therefore this is a case where there ought to have been onward orthopaedic referral. my Lord, I'm at page 7 of our skeleton and Brown 2, factual causation in relation to the third defendant. Factual causation in relation to the third defendant, the judge, in essence, accepted Mr. Langdon's factual evidence about what would have happened had there been a call that morning, although got the time wrong in her paragraph 54. I beg your pardon, not paragraph 54, it was in a different paragraph, 8 o'clock. But paragraph 54 and paragraph 45, where this issue is dealt with. 45 is perhaps the four lines up from the bottom. Dr. Swale fairly conceded, if I accept the factual evidence I heard from Dr. Langdon, which I do, that any GP who tried at 6 o'clock to refer a suspected CES directly to the orthopaedic department rather than A&E would be informed to go through A&E. And then at paragraph 54, the indication that she does accept that factual evidence from Mr. Langdon. Of course, what we have in paragraph 54, my Lord, is the phrase, 3 lines from the end, he would have been advised to reroute the claimant to what we don't have any consideration of is what ought to have happened, what should have happened at that point. It's simply an acceptance of Mr. Langdon's evidence that that would have been the response had there been a call at that time of the morning.
But that evidence is evidence of fact, it's not evidence of opinion.
No, my Lord, but the judge should have approached this by reference to the expert evidence and what a reasonable orthopaedic doctor would have advised had they been called at that time of the morning. So the factual point, what would have happened, is not the end of the show.
No, I understand that, because what could be said is, if that is what the orthopaedic unit at Watford General Hospital would have said, is you can say, well, that's simply wrong, shouldn't do that.
Yes.
But so far as Dr. Tanner is concerned, why is the conclusion of the judge determinative on the issue of causation?
Because that would be an incorrect approach, my Lord. Because the judge has to turn to not only what would have happened, but look at what should have happened.
Just from the point of view of Dr. Tanner.
Yes, my Lord.
Forget D1, D2 for them.
I am forgetting, my Lord.
If Dr. Tanner had done that, then
yes,
on the balance of probabilities the judge has found, still Mr. Hewes would have been sent to A&E. So why in that case does that not mean that on factual causation Dr. Tanner is absolved?
Because, my Lord, the judge, in terms of general principles, one defendant cannot escape liability by simply asserting that another defendant would have done something that was negligent.
Yeah, but in point of fact,
my Lord, yes, that's the would.
The matter would have been referred to A&E.
But it doesn't. The judge doesn't.
So, assuming there had been negligence on the part of Dr. Tanner, how can it be causative of any ultimate loss?
Well, my Lord, because in our submission, it's not what a reasonable and responsible orthopaedic doctor should have.
I understand that, but Dr. Tanner can't take responsibility for how the orthopaedic unit at WGH would deal with the matter.
But that's not quite the way one should approach it, my Lord.
Right. Tell me how I should approach it.
Well, we've looked at the issue of Dr. Tanner's breach of duty already.
Absolutely. We're talking about causation now.
We're looking at factual causation, pure and simple. And so there would have to be a timeline constructed as to what would and should have happened had Dr. Tanner made that call. Now, Mr. Langdon's evidence, as the judge accepted, deals with what would have happened. However, the judge does not then go on to deal with what should have happened, which is a required step per Belitho. And so the court should look at the expert evidence as to what ought to have happened in response to that call.
I can understand that, but I'm still asking you to focus on the position of Dr. Tanner.
I am, my Lord. And my general submission, my Lord, is that if we assume for a moment that Dr. Tanner was negligent. A negligent defendant cannot then escape liability on the basis of saying a co-defendant would also have been negligent, in fact, and therefore would simply have redirected this patient to A&E.
Supposing Dr. Tanner discharges what you say is his duty and sought to refer Mr. Hewes to the orthopaedic unit, and Dr. Tanner then discharges duty, rings the orthopaedic unit and says, I've got an urgent CES case here, please take him straight away, right?
Yes.
So on the face of it, he's then discharged his duty.
Yes.
Suppose then the orthopaedic unit says, as Mr. Langdon says it would have said, no, send him to A&E. How then is Dr. Tanner somehow still liable?
No, he's not if he's made the call, my lord. That's the point. Because he's made the call, he's not in breach of duty. And so you effectively stop the chain there. One has to assume, and obviously it's a hypothetical timeline in every case, that if Dr. Tanner had made the call, not only what would have happened on the balance of probability in relation to that call, but what should have happened, relying on expert opinion for what should have happened, and expert opinion from the orthopaedic experts.
I have the same difficulties, my lord. I don't understand this. What we're trying to assess is what loss has been suffered as a result of the assumed negligence of Dr. Tanner.
Yes.
One has to construct an assessment of what would have happened had Dr. Tanner done what he should have done, and what he should have done is ring up.
Yes.
We know as a matter of fact, on the judge's findings, from what Mr. Langdon said, what would in fact have happened is that he would have been told to route it through A&E. Why does the inquiry not stop there? Dr. Tanner's assumed negligence made no difference to the outcome. Why is that not the end of the inquiry? What is the principle by which, instead of looking at what would have happened, you construct a hypothetical world in which a different A&E, different general hospital, would have hypothetically done something different? What's the principle which applies? I have great difficulty with understanding it.
In our submission, this is pure Belitho, and it may be helpful to turn up Belitho in the authorities bundle at tab 3, page 46.
But Belitho is about negligence, not about causation.
It's not just about negligence, it's also about causation, my lord. And people often forget that it's about causation.
Well, it's decided.
Well, yes.
Causation.
Well, no, I can see. No, it is about causation, but it's about what a particular defendant would have done. And I can see if you're asking what a particular defendant would have done, you ask what they should have done. But I don't see anything in Belitho which says if one defendant is negligent, they can't, for the purposes of causation, investigate what another defendant would have done, but only what they should have done. I don't see how that follows.
My lord, it's page 46 at B. However, in the present case, the answer to the question what would have happened is not determinative of the issue of causation. At trial, defendants accepted if the professional standard of care required any doctor who attended to intubate Patrick, Patrick's claim must succeed. Dr. Horne could not escape liability by proving she would have failed to take the course which any competent doctor would have adopted. A defendant cannot escape liability by saying that the damage would have occurred in any event because he would have committed some other breach of duty thereafter, and then reference to Lord Justice Hobhouse in Joyce and Merton, Sutton and Wandsworth. And then between F and G, there were therefore two questions for the judge to decide on causation. One, what would Dr. Horne have done or authorised to be done if she had attended Patrick? And two, if she would not have intubated, would that have been negligent? Burnham test has no relevance to the first of those questions, but is central to the second. And
Well, that doesn't meet the situation we're discussing.
My lord, it's my submission that where there are two defendants, that the first defendant, or in this case third defendant, cannot rely on subsequent negligence of the first defendant to avoid a finding of factual causation.
I don't see it in Belisle because there it's
different, yes.
The damage would have occurred because he would have committed some other breach. That's looking at the same defendant.
Quite.
So if it's not in Belisle, are you going to show us somewhere else where it is?
My lord, my lady, that may be a convenient moment.
Yes.
So you can put on your flak jacket over lunch. All right, fair enough, Mr. Booth. Also, I should warn you that I'm probably wrong about, but when I don't understand an argument, I tend to start thinking it's wrong. And at the moment, I'm not understanding this point on causation. Can I just reiterate, certainly perhaps you and Mr. McLeish can take stock. If, and we're hypothesising, if Dr. Tonner had done what you say he should have done and rung orthopaedics and say, I've got this man, you should see him, orthopaedics, urgently, and orthopaedics say, no, we won't, he's to be sent to A&E, I just don't see what more Dr. Tonner then can be expected to do.
My lord, that's not quite the point. As I explained a moment ago, if Dr. Tanner had made the call,
yes,
then he discharges his duty on our case. So his call to orthopaedics at Watford General would have discharged his duty, and had he made that
and Mr. Langdon has given evidence, and point of fact, had he done that, then he would have been referred to A&E anyway.
Oh, yes.
And why isn't that in factual causation terms determinative?
Because, my lord, it doesn't deal with whether the response of the orthopaedic department was a reasonable response.
And that should be attributed to Dr. Tanner?
My lord, yes.
Right.
He is in.
I definitely need my can of Red Bull, so let's go. Okay. Right, I hope we will be able to finish by this afternoon, but we'll see how we get on. But we'll start again at 2 o'clock. Is it 2 o'clock convenient for everybody?
Thank you, my lord.
All rise.